The way you prove the elements of your case to the judge is by testifying, telling your story while under oath in court. It is very important for your story to be the same every time. You should answer all questions honestly. Remember that if a judge thinks that you have not testified truthfully about even a minor fact, it may make him or her not believe the rest of your testimony. You must also answer questions from the defendant's attorney or the judge simply, honestly, and directly. Try not to argue with anyone who is asking you questions. When giving testimony to the court, there are a few important rules to keep in mind. You are not allowed to offer testimony that is hearsay. Hearsay is a statement that was made by someone else outside of the court that you are presenting as the truth. For example, my mother told me that she saw the defendant slash my tires. That statement is hearsay and cannot be considered by the judge. If you feel it is important evidence, you should arrange for your mother to be a witness so that she can give direct testimony. Evidence might include photographs of your injuries. Even if the police have taken photographs of your injuries, it is a good idea to take your own pictures and bring them with you to court. After you testify about receiving a particular injury, you should make the judge aware that you have pictures of your injuries. The sheriff's officer will take those pictures from you to show them to the judge. It is important to tell the judge that the pictures you are providing are true and accurate representations of what you testified. If you sought medical attention because of your incident of domestic violence, it is a good idea to obtain your medical records. When requesting these medical records, you should ask that the records be certified. This means that your records will have a cover sheet on the top that tells the court that the records are true and accurate copies of your medical records. This cover sheet is necessary for the court to consider the contents of your medical records. After you testify about seeking medical treatment, you should ask the court to review these medical records. There are many different types of evidence, including text messages, voicemails, and phone records. The goal of evidence is to support your testimony and help you to meet your burden, the preponderance of the evidence. With any evidence that you present, it is important for you to authenticate that evidence. This means you must testify that the evidence you are providing is an accurate representation of the facts. You want to tell the court what this evidence is, how you obtained it, and how it helps your case. You also have the opportunity to present other types of evidence to the court. This might include witnesses of the domestic violence. Any witnesses you bring to the court must have personal knowledge of an act of domestic violence committed against you. The court cannot consider a letter from your witness, even if notarized. You may want the police officer involved in your case to testify at your final hearing. In order to do that, you need to provide notice in the form of a subpoena. You would want a police officer to testify when that officer has personal knowledge of what happened in your situation. This may occur if they have seen your injuries, if the defendant admitted to an act of domestic violence, if they saw damaged property, or if they can testify to your demeanor. Once you testify, the defendant or his attorney has the right to cross-examine or question you. Cross-examination is a means of flushing out any inconsistencies in the opposing party's story. Similarly, if any witnesses testify, they can also be cross-examined. After being cross-examined, the plaintiff will usually have the opportunity to explain any inconsistencies that were raised during cross-examination. The vehicle for this is redirect examination. Here, your attorney will ask you additional questions to clear up any seeming inconsistencies brought out by the defendant or his attorney. Or if you are not represented, you will have one final opportunity to talk about the domestic violence. Once the plaintiff has finished, the defendant will be given the same opportunity to testify and present witnesses and evidence. Now you will have the opportunity to cross-examine the defendant and object to any testimony or evidence deemed inappropriate. Throughout the proceedings, it is important to not only show respect towards the court and your own attorney, but also towards the opposing counsel and the defendant. It is therefore not appropriate to laugh or sigh loudly, throw your hands into the air incredulously, or otherwise blatantly show your frustration while the defendant is presenting his case. This not only detracts from the overall proceeding, but may also irritate the judge and the attorneys. When both you and the defendant have finished presenting your cases to the court, the judge will then give his or her opinion. While the judge is giving their opinion, you are not allowed to speak or present any additional evidence. During their opinion, the judge will inform you whether your temporary restraining order will be dismissed or become final, and provide reasons for his or her decision.
If you need legal advice or representation, you can see if you are eligible for our services by calling 1-888-LSNJ-LAW or completing our online intake at www.lsnjlawhotline.org.